Welcome from the halls of justice, and we're back with the honorable local hero, our wonderful Judge Rudolph Diaz, and he is one of the hardest working judicial officers you'll ever meet, and it agrees with him. You look marvelous.
Well, you're doing pretty good yourself.
Thank you, thank you. I tried running with Judge Mitchell, and I made it about 5 blocks and went home, but it's all right. At least I can say I tried. I kind of went there. Also, we have the wonderful Nicholas A. Salick, attorney at law, specializing in family law and children with disabilities. His clients just think he's wonderful.
I hope so.
Hardworking gentleman, a machine. So we left off at a few questions that we didn't get to finish, so that's good. And we are in West Hollywood on local channel 36. So, and you're from the halls of justice. So, with that being said, we're going to maybe not put you on the hot seat, Mr. Salick, but maybe just a few questions for you. What would you think, Judge Diaz?
Want me to ask the questions now?
Sure.
All right. You mentioned that you were in family law and you had a focus on children with disabilities.
Yes.
Okay. Could you tell me how that works for you? First of all, how a private practitioner gets into it?
Yes. With family law, there are, so you have minor children who, I guess for the best way to describe it, age out of the court system when they reach the age of 18, or basically, in short, when they reach the age of majority. But special needs children, most commonly, at least in my practice, children with autism or severe disabilities, that doesn't stop once a normal minor child ages out of the child support system, and then when you have special needs children, certain special needs children, you then get into the realm of adult child support. Mm-hmm. You also get into, not to get too technical, but the Family Code Section 4062B, which are discretionary add-ons for child support, and one of there's 2 subcategories in that section. One of them is special needs expenses. And so, of course, it depends upon the ability of the parents, or usually the supporting parent, to pay, and also the reasonableness of the expenses. For example, you're not going to order someone to pay adult child support special needs expenses if they can't afford to pay it. So you still have to weigh the ability to pay, and but in any event,
that question is on local Form 150, right?
Yes, it is. FL 150.
Yes.
But so with respect to for special needs children, if there's an IEP involved, or on a for usually temporary disabilities like a broken leg or a broken arm, they have 504 plans. But for an IEP, if one is issued by the county or by the school system, then there are certain services that are proposed, and for example, occupational therapy, speech therapy, private tutoring, nutritionists, and et cetera, et cetera. And so those cost money, and so if those are not available through public funds, then it certainly can be ordered by the court if the attorney or the party meets all of the statutory requirements. But I think to give you very specific examples with respect to autism, you have children with who need homeschooling. Okay, so you have children who have mental health issues. I had a case recently where there's a 13-year-old moderately on the autism spectrum. He was moderate, but he'd been hearing thoughts and voices for about 5 years, and it very much upset me. We were at trial, and neither parent was acknowledging, one, the severity of the child's hearing thoughts and voices, which was common knowledge to both parents, but more importantly, neither parent was taking this seriously and surely not realizing this is not going to stop when he hits age 18,
Wow.
when he graduates high school. And so, that's when my advocacy kicked in, and one of my arguments was I really couldn't believe how much mom didn't care about this. And it seems like I care more, and I'm not even the child's parent. So we ended up getting the order. We got the order that I think was appropriate. But I got on this track. One, my brother's special needs. He didn't get enough air at birth, and so he gets services through the West Side Regional Center. My sister is a clinical psychologist, and her specialty is children with autism. She worked at the help group in Culver City, and now actually she works for the family court system, doing custody and visitation mediations and parenting plan assessments. But I found that a lot of my clients had
she's
these.
busy.
Yes, very busy. but there's also someone who's available who has the requisite experience and education to do mediation services for parents who don't have the financial means to hire a private counsel. So they actually have a mediator through the court services system who has experience dealing with parenting plans for special needs children.
So are you retained by a parent, or are you appointed by the court for your services?
No, I'm retained by parents
By the parents?
in these situations, yes.
All right.
To advocate.
And is that incident to a family law issue, a divorce, or is that it just comes up separately?
No, there's three areas, main areas of family law that I practice: divorce, which could be pre or post judgment, paternity cases where there's children that are born outside of a marriage, and domestic violence cases. So usually my role, I'm usually retained by the parent who has primary custody of a special needs child, or is seeking primary custody, or is seeking, for lack of a better phrase, legal muscle to go into court and explain to the judge and show the judge why certain relief is required, what these special needs are, because I don't. Newer family law judges don't have I don't know if there's training, frankly, for them to fully comprehend all the different areas of special needs. And certainly, the discretionary add-ons, so, it's my role as an advocate to educate and explain to the court how the court can grant the relief we're requesting. If it's a need and ability argument, explain what the financial means are of each party, the child's need for the services, the parent whom we're asking to pay for the services, whether they have the ability to pay it, and the need for the services.
Well, I've worked both family law and dependency, 4 years of family law before my current assignment. And of course, we deal with the issues that you're talking about every day. But we have immediate resource. We have people who are trained. We have a minors attorney, as well as attorney for each of the parents. And the judges are also trained in this area. But we don't have to, we can just make the orders is what we're doing. And we have all the other professionals to make sure the orders are carried out. But I do remember in family law, these issues almost never came up, where we really focused on those kinds of questions. So, and I used to appoint minors attorneys to help me at least identify the issues, because usually it's just one parent against another parent and custody and it's child support issues, but not about the specific needs of the child. And the first time I've heard someone like yourself who really just is focusing on those particular issues for the child. Sometimes it might even be a conflict, as far as I can see, between you representing the parent and the child's needs, because maybe that parent, him or herself, was negligent and is being negligent at the time as well. So that's why I used to try to hire, or appoint, I should say, minors counsel on a lot of my cases, and it just became burdensome for the county. And it was also during the recession that I was in the family law, so people frowned about all these added expenses at the time. But which is one of the reasons I moved to dependency, because I really became very concerned about children and what we were doing for them. And I said, it's my chance to go out a winter and see if I can help some children while I'm doing it.
Well, what I noticed, I'm not speaking for Mr. Salick because he probably knows way more than I would know about this. But what I did notice is that in family law, I've been a family law paralegal for 16 years, 17, whatever. I'm still just 38, 39. Yeah. But whatever. But with that being said, I did notice that when we got into the dependency court, that between the language in family law and dependency court, it changes. There were terms and terminology that I wasn't accustomed to that I didn't know in dependency court, and I had to learn. And
it's kind of a different language.
Yeah.
And our focus is two targets. We want to protect the child, and we want to reunify the family.
Okay.
And sometimes these conflict, but that's still the primary focus is reunification. And when that doesn't work out, and there's a time limit, then it's focused on the best interest of the children. But it's always best interest, but by the time the parents have had an opportunity and don't cooperate, and that happens unfortunately a lot, it's now, what do we do to this child? And like I said earlier, bringing the child into the system is usually traumatic itself, and I'd like to see us get them in and out of the system as fast as we can, or at least away from the courthouse and away from the litigation. And you were talking about when you turned 18. It's changed now. Children can stay in the system until they're 21, but they have to choose to stay in the system, and it really works well because their mindset is that they have to choose it. So they're resisting when they're 14, 15, and they're never going to go home because the parent never reunified or is no longer involved. It's tough for those kids, and they constantly resist, and they're always fighting the system and foster care and everything, going to school. But then by the time they're 16, they're now being told, in 2 years, you're 18, you're an adult, you're going to be making your own decisions.
Right.
And are you ready? And you got school, and where do you want to go to college? And so they're starting to think about it, and when they're 17, they've already decided, I'm going to stay in the system. And they can stay until they're 21. They don't have to stay in California if they're going to college somewhere else, and they do.
that's great.
And we're really proud to see how this program has enabled children to really focus on themselves, because they have to now, and to make decisions. And the monies that would go to foster care are going to go to them, so they have a little bit of money to
That's
be
great.
responsible for. But we're there to continue to provide them assistance. A lot of the kids I remember hearing this many years ago, who've been 17, 18 years old and ready to apply for college, and they had nobody to go to help them fill out the application. They just didn't know what to do. They didn't know anybody. So hopefully we're there to help do those things now.
Like the self-help center for the family law category. So that's wonderful.
It is.
That's great.
Yeah, it is.
Yeah, we were talking about that with the Judge Mitchell attitude in the Midnight Mission. That, like I said, I think that's just awesome that you were helping the teenagers with the running. Because, like I said, Judge Mitchell has changed so many lives with his running program.
Right.
And then I didn't know that you had been involved with the teenagers for a running program.
It was a great experience. So I ran too. So I'm a runner myself. Was a runner.
Well, I tried. I
go back a few years, and I ran with them. In that marathon. And
Wow.
so that was important to them too, to know that I would be there with them, as well as one of the counselors, as well as one of the clerks in our court. He was a retired Marine, big guy. And did all the barking at the kids. But they need a little bit of that. But, they became different people. I mean, if you ever had a chance to run a marathon and you run a marathon, when you're done, you really feel different. you know, you just accomplished something that you've never imagined that sometimes.
I bet you do, because Judge Mitchell runs with his runners, and from the short time that I ran at the Pasadena Rose Bowl for that distance that I did run, when I got home, I could not attend church that night, and I was laying down for about 3 days after that. I was okay after but I was in pain.
Well,
I didn't think I was in that much, but I was in pain.
You know, you have to do everything in moderation, especially as you get older. Not that you're getting older.
Well, no, I got caught up in the spirit. I was like, oh, they're running. I'm going to run too.
Yeah,
But
here you think you're 22.
Okay.
But the rest of you says, get
Well,
real.
I told you I'm 30. What did I say? 8, 9, one of those. Yeah. I'm basically a very honest person, except when it comes to my age and my weight. And I'm a woman, and that's my prerogative. So, okay, Mr. Salick, I know that you had some other wonderful questions that I won't steal from you that you wanted to ask Judge Diaz. So what did you want to ask him?
May I
Or-
peruse the
Let me
sheet?
tell you, what are your peeps?
Yeah.
My peeves?
Yeah.
So I've been doing this for family law litigation, for a little over 12 years now. And, you know, this is common amongst my colleagues, and it actually mirrors a complaint that you made earlier. Every now and then you'll get a situation or a judge who has not read the pleadings, and it's very clear and obvious that the judge hasn't read the pleadings, and you can't say, you know, unless you want to be cited, you know, you haven't read the pleadings, Your Honor. And so I've developed ways to, you know, to tip off the court, but that's my own ways. But it's very frustrating. It was, and it still is, to put a lot of work into pleadings, and, you know, to prepare them. Your client gets charged for them. You know, opposing counsel prepares them, and they get submitted to the court, and then it's clear that they haven't been read. And I'm not saying these are not. These are safe assumptions. Let's put it that way. There was one time I appeared in Orange County, and the judge, which I was very grateful for, just came out and said, you know what, I just got back from vacation, and I haven't read these yet. I'm really sorry. I need to continue the hearing. And I thought that was fantastic, because when I was younger, and even, you know, every now and then nowadays, if I don't know a case or a code section that's referenced by the court, I'll say, you know, I apologize, Your Honor, I'm not familiar with that case or that code. I guess that's kind of a complaint of mine. I don't know if I can really ask you a question.
It's fair. I mean, and it does happen, you know, especially in family law, frankly, where I was at. And there are some times when you just get, you know, stacks of things to read, you know, and it's our obligation to plan our calendar so that we'll have some time. And sometimes that means you take it home with you on the weekends as well as in the evenings. But I would do, and I've done exactly what that judge did for you, which is say, look, I was not able to finish reading everything I have here, and so I need more time, and so I won't make a decision. You know, I'd rather not make the decision, you know, have you peeved at me for not reading it, than to try to reach a decision that's just not going to be fair, because I haven't really, maybe I don't know the case that you cited, but I think it's important to be fair. I mean, no one wants to be reversed, you know, so that's number one too. Of course, I want to make sure I'm not going to be reversed, but it's also fair to the parties and to you lawyers who put all that effort to read it and be ready for it. So I have done that. I've just said, I just cannot finish reading everything that you have here, and I don't want to decide, and I do want to give you a chance to make an argument, saying I want to make sure when you argue it, I know what you're arguing from. So that happens, and that's a fair peeve that you might have about judges who haven't read it, but they should make an effort. And just sometimes we're not going to do it because we just didn't have the time. You were sick, you were on vacation, or something else came up.
Well,
I find that to be very refreshing, frankly. I mean, if a judge just flat out, I mean, I have not read it.
Sure.
You know, come back in the afternoon, or why don't you come back next week? I'll fit you in.
That's
much better than, you know.
Yeah, I would do exactly what you just suggested. Come back in the afternoon. You know, I mean, I'll spend my lunch hour, which is what I do a lot anyhow these days, and they did it when I was in family law as well. I'll just read it during the lunch hour and see if I've had enough time to read it. Because I think, I think we have an obligation. This is our system. This is one thing, being in the system so long myself as a judge and getting to know judges throughout the state and some of the incredible people who are judges. And,
Yes.
It's our judiciary, and it's up to us, to make it work. It's up to us to make it the best we can make it. And so individually, we have our personal obligation to make sure that we're being good judges, and not just in our work, but as I said earlier, in our appearance, that we maintain certain standards of ethics and so forth. That's ours.
I've had the opportunity to, it's been a very rare occasion where I've had a vacation. I've been working for years and years and years. But one of the things I enjoyed doing when I was on vacation was visiting the courtrooms. Sure. So I've actually had the honor of going in, sitting in the courtroom and listening to a judge, and I've seen a couple of things. One was an absolutely wonderful judge who stated that after listening, it was a lot of money involved to both sides, and they were both very passionate in pleading their case, and their forensics had everything. And the judge just told them, you know what, I'm going to have to, call a forensic of my own to go over this and go and decipher it. I had the opportunity to sit in another courtroom where not only there was the judge and the clerk and the stenographer, and he had a recorder in his chamber in the courtroom, so everything he could play back and he could listen. I was impressed, and just I've had the opportunity to just meet some wonderful, outstanding judicial officers who truly care about the people of the community. So
I think that's the general sense I have about judges. We see it as a privilege, we see it as a responsibility, and it's up to us to make this thing work as best as we can. And I saw that throughout the entire state when I was, as California Judges President, and saw. And it didn't matter if you were in a rural area or you were downtown Metro Court, and people just wanted to do the best they could. And that's just a great reassurance, I hope, for attorneys too, that we do think what you say and do is important. And we are, in a sense, trying to work together to make this system, and you're part of it too, obviously, the advocates, and eventually you're going to have a role, maybe, yourself in this, so hopefully you will if you want that.
It seems to be very, very difficult. I've often asked myself, I don't know how they're able to, the judiciary is able to take on the responsibility and the task of coming up with a ruling that the parties can't reach on their own, that the attorneys can't negotiate on their own. It seems extremely difficult.
you should do a judge pro tem. That's
In traffic court?
Well, I when I was a lawyer, I used to try and think like a judge. So I would know where the case is going, So I knew I was an advocate, and I knew what the other side was probably going to say, but I was also thinking about what is this judge going to do? How's the judge going to look at my arguments or evidence? And so I started thinking like a judge long before I became a judge.
yeah.
Wow, that's so interesting you just said that, because I've started to do that with certain judges.
Yeah.
I will tell my client, and my client's like, hey, what about this? And I'm like, well, this, I'm just going to play devil's advocate. This is what I think Judge so-and-so would say.
Right.
What about this? What about that?
Yeah,
Absolutely.
I practiced in federal courts and in criminal law before I became a judge. And we
Wow.
had something like 25 judges downtown Los Angeles. And I worked there every day, so I got to know all the judges. And I got to know their sentencing, and I got to know how they rule on evidence. And so I could tell a client, what I'm going to do is that when I first met them, I'm going to find out what the evidence is against you, and then soon we'll find out which judge. And it says, and after, give me a day or two, and I'm going to tell you what's going to happen, and you're going to tell me what you want to do, what I can do. But, your mind starts functioning like that. I'm trying to find the end result here, and I think I know all the parameters of law and how well I can do, and how how well I can do with that particular judge. And some judges just don't bend, and so it's just an uphill fight no matter what. And in most of those cases, you lose.
Now, see, I was going to say, with my personality, that's why I really admire and respect you so much, and even Mr. Salick, because with your knowledge, I really wanted to go to law school and become an attorney. And
Not too late.
And that's right, because 39 keeps hitting me. And but with that being said, I had the opportunity with a very beautiful lady and her husband, Tally and Bill Wagner, who wrote the Rudders Group. I mean, it was awesome, and I had a chance to see him speak, and he was with a federal judge. And one of the things that they talked about that night was great. It's like what you said, which was, at the end of the day, you got to present the law. You know, don't waste my time. Don't keep coming back with frivolous things. You have to present the law. There's a certain amount of emotion that you might bring into it because, of course, we care and you want to present it. And I know of one particular attorney that he turned out to be just somebody that needed prayer. He needed Jesus. But after 45 years, he knew the law. Mm-hmm. And he wrote the shortest pleadings I had ever read in my entire life. But it was because he knew the law. Mm. And so he wasn't a very nice person, but he knew the law. Mm. So he would cut out a lot of emotion, and he would go straight to the heart of the law and the matter in the pleadings. Mm-hmm. So that was the one good thing I learned. And it's too bad he wasn't nicer, but he was smart, a little too smart for his own good.
I used to do appellate work, too, in connection with my federal criminal practice. And you're limited. You only have 20 minutes to argue, I think, something like that. And so, you can lay out a bunch of arguments and issues that you can raise, but only one or two issues are going to get you a reversal. And so you have to make sure that you're focused on what that is and that you're making the right arguments and responding to the other side and answering the questions that the courts are going to be asking you. So you have to stay focused,
Yes.
Yes.
Mr. Salick, we've got 43 seconds. What would you like to say? Anything you want to wrap it up with?
Aside from this being an honor to sit with your honor, to someone who, a judicial officer who's so esteemed and accomplished, it's a great opportunity to be able to ask these questions, which have been in my mind for all these years. So thank you for the opportunity to.
Things
and
that
thank you for
irk
answering,
you,
more
yeah.
importantly.
Well, I thank you for your question and your interest, and also, and I hope maybe I can inspire you also to think far in the future for yourself too, and you too.
You're our local hero. Thank you for joining us on From the Halls of Justice, and a shout out for CASA on the teddy bears for the children.
Oh, yeah.
Join us next week. Thank you so much for caring, and thank you, gentlemen, so much for being here.
My pleasure.
Thank you.
Thank you. Awesome. Just totally awesome.